the order dated 2/70/20 passed by Justice Bhubaneswar is set aside.
Great.
Item 2.
Case of the petitioner is directly covered by the judgment, the Honorable Supreme Court, B.V. Agrawal and Nikhil Marchand Chopra. Therefore, the petition is allowed.
Wait for minutes. Item 3.
Disposed of the petition with certain observations.
4.
The review petition is dismissed.
Item 5.
The appeal is dismissed with certain liberty reserved.
Item 6.
Although I'm not inclined to interfere with the MP order at the belated stage, however, certain liberties granted to it.
Item 7.
I have made certain observations regarding the liberty of an individual, and thereafter, by allowing all the petition, directed the release of the petitioner forthwith.
Before your lordship, item 6 may be approved for reporting because our Odisha, there is no such judgment as I report to.
Which one?
Item 6.
6.
Your lordship judgment should be reported.
Yes.
Your lordship, I pray before your lordship for reporting. Our Odisha High Court judgment is not there, my lord.
Yes, yes.
Obliged, man.
Yes.
Mention as Chairman's matter of 2023. The trial has been stayed pursuant to the interim order of this Honorable Court, my lord. It's a matter involving offence under section 302. I have filed an IA for vacation of stay, my lord. I'm for the info
302.
302.
And trial is stayed.
Stayed. At the discharge application before this Honorable Court, after that, the trial has been stayed.
Yes.
Filed an IA for vacation of stay.
Get ready and come. No question of hearing application. There is a stay, either this way or that way, I'll allow or dismiss, whatever.
Criminal division of case and vigilance.
Give. Yes. Give him a money. Build up. Build up for the. First admission will come. She really. Yes. 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 Yes.
Item 8 to 16.
Item 10.
May I please your lordship?
Next
Okay.
Thursday, Lord. 1 minute. She is getting restless. Yes, yes, madam.
Lordship, I have to pray only one matter, CRLMC 3854 of 2024 for modification. Possible. Kindly.
Modification.
And
Okay. Okay. Yes.
Item 10, Lordship.
10.
Pray
Yes.
for next week, Lordship.
Okay. On the request of the
First day, Lordship.
Yes, madam. Yes.
Item 17 to 30.
Item 12, my lord. I am the informant, opposite party.
I am for petition.
My lord, last occasion, lordship directed to personal appearance of the informant. The last of the case was listed with the Lawrence senior, appearing the Lawrence senior was ill. What the
What do you want now?
one week after Asu,
Next.
On the request of the party, leave the matter.
and my lord appear the informant personal appearance last.
Matter is settled.
No.
Affidavit also file compromise petition. Defer to
Once
your
you bring them. If you
It is
yes.
court directed to appear the informal last.
If it is next time. Yes, next.
Item 17 to 32. 33 to 44. 51. 52 to 60.
Due to item 52,
Yeah.
and for the information. Sorry, counsel challenge that I think is state Miller. Inspector Lord's direction, they have not filed the requisites. I am voluntarily appearing of number 2. Since the trial has been stayed, Lord's may stop.
You are appearing?
I can counter box.
Requisite not filed.
Not looking is the appeal date have not filed requisites.
Wait, I'll impose little cost. Wait, I'll take your wakalat, no? But since they have not filed, either in stay or anything,
Yes, yes, but in the trial.
so then they have to pay the cost. Okay.
Item,
Let it come. Let it come. Okay.
another item 58. It is a husband matter that not formula to see another one or two implement time.
Okay. Okay. On the request of Land Court for petitioner, adjourned, no? 58. Yes. Consolidated cost title filed. Notice could not be issued due to late filing of. You need in the other matter. You need cost in this matter. You pay cost here also, and you will be compensated in the other matter. The requisites already filed popular upside.
63.
Yes.
61 to 71.
Pardon me, Lordship, item number 67, I pray for adjournment for 2 weeks.
67.
Yes, sir.
Okay.
Interim order to continue.
So you have taken interim order. Why are you asking for adjournment?
I am the petitioner, opposite party.
You have any objection?
No, man.
Okay.
In this case, opposite party
Right.
is seeking adjournment. We are for the.
Objection from adjournment. 67.
Item 63.
File, my lord. I
65.
pray an adjournment, my lord. Lower court counsel has taken the file, my lord, for Xerox, my lord. Not returned me, I pray.
Okay. On the request of counsel. 65. Huh?
63 million.
Yes.
1 week after, I am not well today for that. Interim order to continue, my lord.
That counts for the petition.
Interim order to continue, my lord.
Suppose, hence he is seeking adjournment. Lease the matters also interim order to continue.
Interim order to continue, my lord.
Yes.
Item 65 also interim order to continue.
Interim order.
72 to 79. 80 to 89.
Lordship, item 85. And for the appellant, Lordship. Lordship, the deposit receipt has not been received yet. Need 2 weeks time to file the deposit receipt.
Yes. What do you want
2 weeks time.
for depositing the amount? Simply adjourn. On the
Time of filing of the appeal, the certificate should be accompanied to the appeal. That is the law.
He is going to deposit within a week.
I think it is taken on 24th on settlement, it can be disposed of.
Can it be settled?
24th. Yes, your Lordship, it can be settled. Once you deposit the deposit receipt, it can be settled.
Fixed date.
Release amount.
Okay.
If you settle, then third
3rd of March. Your Lordship.
3rd March.
3rd of March. Your Lordship.
3rd of March, he will deposit thereafter settlement.
Published.
Yes.
90 to 94.
90, Your Lordship. May please, Your Lordship. Item number 90, batch matter, vigilance matter. My lord, it listed more than 22 times, Your Lordship. Since April 2024 till now, it is listing, my lord.
And all 2 occasions have I said in the court or not?
My lord.
All the 22 times I have said in the court. It's as my job then.
Your Lordship, our part is concluded, Your Lordship.
Okay, let us see. Let the other side come.
Other side is the vigilance, my lord. Every petitioner side is already
Mr.
completed.
Sangram Das has to come. Mr. Sangram Das has to come. Yes, let us see today it may reach or may not reach.
Your Lordship, I am praying, Your Lordship, at least fix this matter for 3 PM so that they will take 30 minutes. Our side is totally concluded, my lord.
Okay,
We
you come by
already
3, let
submitted
us see.
convenience
No, it
note,
will take a lot of time. See, there are many matters,
my lord.
many matters. We'll see.
Grateful. Your
3
Lordship.
o'clock. Yes.
Item 8,
May I please?
8.
Well,
Started, huh?
here, my lord, application was filed by the petitioner, who is the informant in the case,
Yes.
for release of the seized cash, which was the cash seized
You are supposed to obtain.
from the accused persons, and that amount has been deposited in the court by the IO, and the informant seeks release of that cash, my lord, because that cash was taken away by the accused persons from his house. That is the allegation, and charge sheet has been submitted. 27 ରେ ତାଙ୍କ ପାଖରୁ leading to discover ତାଙ୍କ ପାଖରୁ recovery ହେଲା, IO ରଖିଲେ ତାକୁ report କରିଦେଲେ court.
What do you say? What is the cash? How much?
5,36,000 ଟଙ୍କା ତାଙ୍କ ସେ କଣ କଲେ ନା ନେଇକି କୋର୍ଟରେ ରିପୋର୍ଟ କଲେ.
If it is his money, then let him use it at least.
ସେ ଲେଖିଛନ୍ତି ତାଙ୍କ deposit slip ଟା ମୁଁ ଦେଇଛି.
Giving.
I have given the deposit slip of the IO. Lordship may kindly peruse that.
This is the charge sheet.
Yes. The deposit slip is at page 16.
1 lakh from the back side of his house in a hole, and which the said case brought from the hole. Produce 1 lakh, na?
1 lakh ତାପରେ ପରେ accused ମାନଙ୍କ ପାଖରୁ ଆଉ rest ପଇସା. ଟୋଟାଲ ଆଜ୍ଞା 20 ଲକ୍ଷ ଟଙ୍କା ନେଇଯାଇଥିଲେ ଆଉ ସୁନା ଗହଣା ନେଇଯାଇଥିଲେ. ମାତ୍ର 5,36,000 ଟଙ୍କା ରିକଭରି ହେଲା, ଯୋଉଟା କି ଆଇଓ ଡିପୋଜିଟ୍ କରୁଛନ୍ତି କୋର୍ଟରେ at page 16.
What is your name? Santosh Kumar Tripathi.
ଆଜ୍ଞା.
You are the informant.
My lord. From my house, the theft was committed. 457,380.
And all the entire amount is recovered under 27.
ମାନେ 20 ଲକ୍ଷ ଟଙ୍କା ନୁହଁ ଆଜ୍ଞା, 5 ଲକ୍ଷ
5 lakhs, the 5 lakhs has been recovered under 27.
Yes, yes.
From the custody of the accused person.
Accused persons.
House
House of the accused
person.
persons.
And then you have to furnish some indemnity.
Yes. Yes, I will furnish that.
Whatever condition.
Yes.
Where is the order? Where is the order rejecting your application?
The order rejecting my application is under Annex 3, my lord, page 17.
What does the court say?
Page 16, first lordship may kindly see. The amount has been deposited by the IO before the learned.
Yes, 5,36,200.
A sealed cash in city case number 1246 of 2020.
Yes. Now, what is the reasoning not giving?
Reason କିଛି ଦେଇନାହାନ୍ତି, ସେ ଖାଲି ପଇସାକୁ ଦେଖିକି କହିଲେ ଯେ ନା ରିଲିଜ ହେଇପାରିବନି ଆଉ. ମ୍ୟାଟେରିଆଲ ଅବଜେକ୍ଟ ଯୋଉଟା ଟ୍ରାଏଲ ପାଇଁ ଦରକାର ହବ ସେଇଟା ରିଲିଜ ନହେଲେ ଚଳିବ, ବଟ୍ ଦିସ୍ ଇଜ ନଟ୍ ଏ ମ୍ୟାଟେରିଆଲ ଅବଜେକ୍ଟ କ୍ୟାଶ.
The denomination, particulars of denomination has to be,
Denomination ଆଜ୍ଞା ସିଏ ମୋ ପାଖରୁ ନେଲେ ତାକୁ ନେଇକି ଧରନ୍ତୁ ମୋ ପାଖରୁ.
The problem is if it is used, you are the informant. If the currency is required,
yes,
then alternate has to be done. Photographs to be taken.
Photographs ନେଇଯିବେ currency ର.
Photographs has to
ଆଜ୍ଞା
be taken.
ଆଜ୍ଞା.
Otherwise it jeopardize the trial. That's the problem.
ଆଜ୍ଞା ସେ photograph ନେଇକି release
And
ଆଜ୍ଞା.
everything.
ସେ photograph ନେଇକି release କରିବେ ଆଉ କଣ. With that condition, lordship may allow.
Or something from his wife and another rest of the amount under section 27.
Yes, right on. At the instance of the present petitioner, FIR number so came to be registered against the accused persons. All accused persons were there. Against how many accused persons total?
Charge sheet said
You tell
Because-
me how many,
because-
much at least you tell.
because FIR is unknown.
By, you tell me how many accused persons.
Jagannath,
A number you tell me.
my lord. Number ହେଲା ପପୁ alias ଚଗଲା ପାତ୍ର, ଜଗନ୍ନାଥ ଦାସ, କରଣ ରାଓ, 3 ଜଣ।
Against three accused persons. Against three accused persons. On the basis of their disclosure statement, 5 lakhs
36,000.
5,36,200 has been recovered from the accused persons. The petitioner, being the informant in the present case, filed an application under 457 CRPC for release of the case, cash seized by the IO and deposited before the trial. We say the application has been turned down. Notice was issued to the state council. On instruction, the council for the state submits that indeed the cash has been recovered from the accused person on the basis of their disclosure. The basis of their disclosure. The trial court, while rejecting the application of the petitioner, has inter alia observed as on page 20, last paragraph, on the perusal of the report. Paragraph and both the paragraph. Mr. Visar, counsel for the petitioner, submits that it is nobody's case that the money belongs to any other person except the present petitioner. Therefore, he is ready and willing to furnish indemnity bond, once the money is directed to the release. And he further submits that the denomination of the currency seized from the petitioner is concerned, the same could be photographed.
Seized from the accused person.
Accused person could be photographed and preserved to be used at
During
the
trial.
time of recording of evidence. Recording of evidence. Regarding to the submission and the facts of factual of the present case, I am inclined to allow the petition. Direct the trial court to release the cash deposited deposited by the IO, deposited by preserving the color photograph of the currency, and the trial court it is open for the trial court to impose any other condition deemed fit and proper.
Hopeless. That indemnity bond part, Lord, see my kindly.
Yes. Yes.
Item 9.
May I please, your lordship? I am in virtual mode, lordship.
Yes. Yes, sir.
Yes, my vehicle, your lordship, has been seized in connection with the case, your lordship, regarding illegal transportation of cow, your lordship. And there I am not the accused, your lordship. 3 other persons are the accused persons. So I filed an application before the London court below for release of my vehicle on
Last time you sought time to read the Dhyan Foundation. Dhyan Foundation.
Last time I was not there, your lordship.
Who was appearing?
The order itself reflected, my lord. In the last order itself
Let me
reflected.
submit, your lordship. My only one
minute.
respect, your lordship. My petition has been allowed, your lordship. My petition to release.
I understand it, but I told you to read the Dhyan Foundation and see the last order.
2024 SCC online 1138.
That is, I have written it in the order itself.
17 pages judgment passed by this honorable court. 1338.
6/12/2024. Order just
I
see.
am not in that. I am not in there, your lordship. My only respect to submission, your lordship. The
Now,
lawyer.
have you seen my judgment in Dhyan Foundation or not?
No, I have not seen, your lordship. I will
Read it.
definitely go
Read
through
it.
the same, lordship. Definitely
That's
go
the
through
order.
same, lordship.
Put
But
it
my
after 1 minute.
Your lordship, 1 minute submission. 1 minute submission, lordship. A lordship have a glance. So far, the condition put by the.
I understand, sir. And see the last order. Last order, you have to see the last order. Last order says, learned counsel for the petitioner submits that he would look into the judgment of this court in Dhyan Foundation reported in so and so, and asks this court as to whether what is the impact of the said judgment in the present case. You have not read that judgment. This is the order.
So tomorrow I will satisfy. Tomorrow may kind will
Tomorrow not possible. You should have.
because
read
your
that
lordship,
judgment.
your old
That
case
judgment.
2023, your lordship. Tomorrow, your lordship, may kind of take up your lordship.
You should have read. See, you are appearing in a matter. Last order you don't read.
I lordship today, your lordship, I today and satisfy tomorrow, your lordship.
No, see, it's very difficult to adjust the list like
Also
this.
Monday, your lordship, passive state or Monday, your lordship.
24. 24. Yes.
Obliged.
Pay for reinvestigation.
Hmm?
Not to pay for reinvestigation.
Reinvestigation.
Yes, your
Yes. Nobody is there. Pass over.
Item 30. My lord. Is it 11, my lord?
Yes.
The
Item 11,
petitioner,
my lord. I'm through VC. This is the second round of litigation, my lord. I'm challenging annexure 8.
I'll just take it up. Sir, I'll just take it up. 11. He has come now. Yes. Yes.
My lord. Well, this is the second round of litigation. I'm challenging annexure 8 at page number 57. For this, my lord, earlier the coordinate bench of this honorable court has directed a learned magistrate to reconsider the matter and observed that, my lord, kindly come to page number 55.
55.
55, my
Okay.
lord.
Yes.
There, my lord, at page number 55, paragraph number 8, I'm reading it, my lord.
Yes.
The court, on a careful analysis of the impugned rejection order under annexure C dated so and so, observed that the learned trial court has been swayed away by the fact that the application has been made by the informant and not by the APP representing the prosecution. This court at this juncture, however, observed that the power to direct the reinvestigation lies with the discretion of the court conducting the trial, irrespective of the fact as to who has filed such an application. Moreover, the informant is competent to bring such application. Other than that, no reason has been assigned in the impugned order. With this observation, my lord, the coordinate bench of this honorable court has directed the London magistrate to reconsider the matter. However, what happened, my lord? At page number 58, I have actually the London magistrate had said that on perusal, the third paragraph, my lord.
Yes.
On perusal of the contention of the petition filed on behalf of the prosecutors, it is found that prayer has been made for direction to reinvestigate the case as because the IO during course of investigation willfully excluded the name of persons, namely so and so, my lord. There are actually 9 accused persons in the FIR and the charge sheet has been submitted against 2. 7 are excluded, my lord, from the charge sheet. But so my humble submission before your lordship is that despite the order of this honorable court, the London magistrate has said that the magistrate had
You could remanded the matter to pass the within order, speaking order. According to thereafter, the London magistrate passed this order.
No, the magistrate says that I can't review my own order.
Yes, your that's right, your lordship. Because on the ground, while the present prisoner any objection that left out some accused person to the in this action has the right to file the protest petition. That not have done, filed in petition also. How the London magistrate after taking convenience to review his own order lordship.
Yes.
The remedy to the prisoner rights will be take the petition of the informant lordship. To file protest petition.
Why don't you file a protest petition?
My lord, I didn't aware of the fact that the charge sheet has been submitted. I only came to know that the charge sheet has been submitted. Cognizance has been taken when the summon to witness has come to me. Then I got the certified copy of the charge sheet and I got to know that despite I mentioned 9 persons in the FIR, only charge sheet has been submitted against 2 persons. Then only I approached the learned trial court with the petition.
Then
and
you can also file the charge protest petition.
I have filed that. I have filed the petition. Earlier occasion, I have filed the petition. On that, your lordship, the London magistrate.
Oh, you are seeking for reinvestigation. The court says no question of reinvestigation. If you are aggrieved, if you think that the police has not brought evidence against 2-3 people, it is 376 it seems.
No, your lordship, there is 498 other alliance proceedings, your lordship.
498.
Yes, your lordship.
498, my lord.
And the in-laws members are present between the husband and mother-in-law. And the present informant is trying to impede the other
Who are they? Who are these people? You want to impede them?
in-laws.
This.
Other in-laws and neighbors are there. I have lost the FIR against the in-laws as well as other neighbors. Because, my lord, apart from 498A, other allegations are also there. That is under section.
What are the allegations? The entire world has tortured you, huh? After marriage.
That is the allegation.
You want to bring everybody into the.
My lord, I have specifically mentioned that who has acted what. And in that light, I have lost the FIR. But the problem is that, my lord, now I have coming before this honorable court is a technical ground.
Show me the complaint. Show me your complaint.
Kindly glance.
Show me your complaint. First off, show me your FIR.
My lord, kindly come to page number 22.
Yes. Yes. What have you said?
ଗତ 8/2/2013 ମସିହାରେ ବାଙ୍ଗୁରୁ ଗ୍ରାମର ତ୍ରିଲୋଚନ ପ୍ରଧାନଙ୍କୁ ମୁଁ ବୈଦିକ ରୀତିରେ ବିବାହ କରିଥିଲି। ବିବାହ ସମୟରେ ମୋ ବାପା ଜାନି ଯୌତୁକ ଦେଇ ବିବାହ କରିଥିଲେ। ମାତ୍ର ବିବାହର 6 ମାସ ପରେ ମୋ ପ୍ରତି ଅତ୍ୟାଚାର ଆରମ୍ଭ କଲେ। ବିଭିନ୍ନ ସମୟରେ ବିନା କାରଣରେ ମୁଁ ମାରପିଟ କରିବା।
All are general
It's
allegations.
omnivorous, your lordship. Marpit କରିବା ସହିତ that allegation is common in nature, your lordship.
No, my lord, that is there, my lord. If the lordship will go through the
You
entire allegation, they have
filed
tried to-
whatever. These are not serious allegations. Don't waste time. Yes.
No, lord, that is allegation. That is ସେମାନେ ଛୁରୀ ଦେଖେଇଛନ୍ତି that if your lordship will go
You have option of filing protest petition. You do that.
That's what I have filed, my lord. That's what I have
That
filed.
is,
No, you ask for
your
reinvestigation.
lordship, kindly glance page 51.
Where is your
answer
application?
5.
Where is your application?
Page 51, your
Kindly
answer 5. That
51.
petition, your lordship.
Application 50.
51, prayer is 2. Reinvestigate, your lordship. That is.
But however, my lord, the learned magistrate have the power to direct further investigation. Even if the magistrate doesn't have the power.
Solid.
And
No,
another thing is that in the order, my lord, the coordinate bench of
It's
this
all right. Now what is now you either you want to exercise the option of filing private petition,
Protest petition.
protest petition, or I'll pass an order. I'll pass an order.
My lord,
These-
sorry, my lord.
These are the proceedings only for misuse.
These are
Nothing.
author charge sheet filed.
I'll pass the order. Give it. I'll pass the order.
No, my lord. Actually, the honorable court has already observed, my lord. Yes,
Remanded the matter to
It's all right. I'll deal with that. I'll deal with it. Yes. Next.
direction, remanded the
I'll
matter
deal-
to petition's regime, your lord.
May it please. But the petitioner and opposite party number 2 were in acquaintance with each other. At Hyderabad, when the petitioner was studying chartered accountancy, and opposite party number 2 was also staying in Hyderabad in the hostel. There was some intimacy, and the petitioner has invested some money on her, paid some money towards the school fees and other things, and he demanded back that money. He has not paid it, and there was an exchange of lawyers' notice between both, that you are liable to pay this, and they are saying that no, all these things. At that stage, at Jaipur, she filed a complaint saying that in Hyderabad, I have misbehaved her. The offense under 294, 323 all were alleged. Therefore, I have come up before your lordships to say that to quash such type
Yes.
of affair.
Your lordship, 387 is the constitution, your lordship, can annexure page 10, your lordship.
Page 10.
Allegation is very, your lordship, real midpoint, your lordship, read your lordship.
10, huh? Page 10.
Your lordship.
Yes. Yes.
Sorry, मते hostel नहीं, I read the mid relevant person.
Yes.
मते hostel सामने मारपीट करले एवं मते मोर हॉस्टेल मोर सांग मान सामने जीवन मारिदा ପାଇଁ ଧମକ ଦେଲେ ପରେ ମୁଁ ଜୀବନ ବଞ୍ଚାଇବା ପାଇଁ ହାଇଦ୍ରାବାଦ ଛାଡି ମୋର ଘର ଜୟପୁର ପଳେଇ ଆସିଲି। ମୁଁ ଜୟପୁର ଆସିଲା ପରେ ମଧ୍ୟ ମତେ ଫୋନରେ ବିଭିନ୍ନ ଅଭଦ୍ର ଭାଷାରେ ଗାଳିଗୁଲଜ କରି ମୋର ଫଟୋ ଗୁଡିକୁ ଭାଇରାଲ କରିବା ପାଇଁ ଧମକ ଦେଲେ ଏବଂ ଜୀବନ ଧମକ ଦେଲେ। ଗତ 8/4/2024 ତାରିଖ ପୁନର୍ବାର ମଣିକଣ୍ଠା ତାର ମାନେ ପିଟିସନର
ତାର ଫୋନ ନମ୍ବର ଶୋ ମତେ ବିଭିନ୍ନ ଅସ୍ତ୍ରଶସ୍ତ୍ର କରି ମୋର ବାହାଘର ଭାଙ୍ଗି ଦେବା ପାଇଁ ଧମକ ଦେଇଛି। ପୂର୍ବରୁ ମୋର ଗୋଟିଏ ବାହାଘର ପ୍ରସ୍ତାବ ଭାଙ୍ଗି ଦେଇଛି। That is the conduct of the present petition lordship.
At Hyderabad, the thing, all these things are, this is our phone.
I'll issue notice only, let us see.
Yes,
Right.
sir.
Because see, everything has happened in Hyderabad.
Hyderabad.
After she came back, she might have contacted over phone or something. They are young people, I think.
Yes, sir.
What is the age of this boy?
CA contact.
26 and 25 and all these people, you know. Okay, issue notice, I'll just issue notice. Yes.
14.
When the petitioner filed for quashing of the FIR, my lord, on the ground of settlement, my lord. So, for the offense under section 341, 294, 323, 354, 506, 387 of IPC, my lord.
Yes.
Lord should fix a date so that both parties will appear and matter will be settled. Fix a date so that both party will personally appear before this.
What are the offenses?
Offense maximum?
What are the allegations?
354, my lord.
What are the allegations?
Allegation, my lord, while the informant proceeded to a TPCL office, my lord, on the way the petitioner abuses him in friendly language and dragged her, outraged her modesty, my lord.
Extortion is there.
Yes. And demanded, demanded
Extortion is
data
there.
button.
Extortion also.
No, any nude photo, anything is taken?
I have, no, my lord. To that effect, my lord, no offense has been prescribed in the FIR, my lord.
Okay, oh, issue notice, huh? Issue notice. Yes.
Okay.
Here, this is a case of 2007. Here, my lord, the present petitioners were facing trial for master tribal offences. And in this case, my lord, some witnesses left without being cross-examined, PW 3, 4, and 5. So, I have filed a petition under section 311 of CRPC, my lord, before the learned court below, and that has been rejected by the annexer 3. So, they are not, my lord, cross-examined at all, my lord. PW 3, 4, 5.
3, 4, and 5.
5, my lord. And
show me their depositions.
Deposition at annexer 1 series, 8, 10, 8 to page 10.
You decline cross-examination?
No, not declined, my lord. On that date, the advocate was not present, and due to his illness, he was, my lord.
What are the offenses?
Offenses, sir, my lord. I have written at page 1.
What are the offenses?
Page 2.
447, 427, 294, 323, 354, 506, your lordship.
And if deposition,
for of the IPC.
if the depositions are read,
what happened? The 3, 4, 5, and 7 are already examined since 2019, your lordship.
Yes,
but they were not cross-examined.
Not cross-examined. To arrive at a judge decision, this case.
You face little cost.
Yes, yes, sir.
Some
Pay
cost.
little cost.
Yes, seafood and master tribal offenses.
Okay, you pay cost to these witnesses, 1,000 each. Huh? Right on. That will be the diet money. Right on. Petition is by the order dated 22/11/2024, passed by learned JMFC for Hon'Ble in GR case number 462 of 2007, whereby his application under section 311 CRPC to recall PW 3, 4, and 5 for cross-examination section. The counsel for the petitioner has taken me to the deposition of the aforementioned 3 witnesses. Indeed, none of the witnesses were subjected to cross-examination. The trial court has rejected the application solely on the ground that the witnesses were examined long back in 2019, 2019, and the petitioner is employing delaying tactics by moving such application to belated states. Apart from that, no other reasoning has been assigned for rejection of the application of the petitioner. section 300 CRP. Needless to needless to say that the petitioner, being an accused, had indefensible right to defend himself. The case he is facing the trial. Since the petitioner has not at all cross-examined these three witnesses, he deserves a singular opportunity to cross-examine these witnesses. Therefore, the trial court is directed. Therefore, the impugned order is set aside. Trial court is directed to fix a particular date for cross-examining the three witnesses. Put it into review in
Without further adjournment.
one day. You can conclude all the three witnesses.
Yes, my lord. One day. With payment of cost of 1,000 each.
Fix a particular date and afford opportunity to the petitioner to cross-examine these three witnesses from the same without seeking unnecessary adjournment. Petitioner is also liable to pay cost of rupees 1,000 to each of the witnesses on the witnesses on their appearance, on the date to fix for the this observation the petition is allowed.
The sub item it is another GR, but it was wrongly tagged. Same question, my lord. Same PW. Here is PW1 only not cross-examined at all. That is 4856. The sub item. It is wrong tagged with this case, but here question is same. 311
No, this
petition.
is another case.
Another case. Same order with 1,000 cost to only PW1 was left.
Only PW. Where is his deposition?
And deposition at Annexure 1.
Same here. Right on. Petition is agreed by the order dated next sub item, that is the item number 4856.
Yes, 4856.
Petitioner is agreed by the order dated 22/11/2024 passed by the Supreme Court of Portamandai, EGR case number 530 of 130, whereby the application moved by the petitioner under section 311 CRPC to recall PW1.
Yes, only
PW1 has been turned down.
Cost 1,000.
It's
What jane to achi?
16.
My 16, only my prayer to issue direction to the learned court below to dispose of the 1cc case earlier as possible as within stipulated time. The 1cc case filed before the magistrate, learned magistrate, regarding payment of wages act, my lord.
2023 matter.
Time bound is there, payment of wages act. My lord, provided that a claim under this act shall be disposed of as far as practicable within a period of 3 months, my lord. Hence,
Which is that provision?
provision under section 15, 3 of payment of wages act, my lord.
15.3 of 15.3, let me get 15.
15, my lord.
15.15
15. 15 of
plus 3.
wages act. 3.
Section 3. Okay. Right. Petitioner in this petition is seeking a direction to the trial court for early disposal of the ICC case number 108 of 2023. 2023 initiated by him under section 15 of the 15 of the payment of wages at 1936. The petitioner, by relying upon subsection 3 of section 15 of payment of wages act, submits that the statute mandate that these kind of complaints shall be disposed of within a period of 3 months. Hence, he seeks a direction in consonance with the section 15 bracket 3 of payment of wages. The petition deserves merit in view of the statutory command for completion of the trial within a stipulated period. Therefore, the trial court is directed to do and to see that the proceeding arising out of ICC case number 108 of 2023 concluded as expeditious. Yes.
17.
The petition is the complainant in 130 proceeding NI Act. So you'll see page 21, annexure 3. Considering page 21, considering the counsel petition submit the petition suffering from cancer, therefore he is seeking for expedient disposal of his case by the trial court. He further submits that he would move an application under section 143A of NI Act before the court below for interim. So the complaint of 2018. So Lordship directed to be disposed within a period of 2 months. So by 30th June, it was to be disposed of. But the accused again advanced a new plea in the court below without cooperating with the trial, that the signature put in the check is not of mine. So it may be sent to the handwriting expert. So I opposed, filed the objection petition. So the my lord, the page 28, the check. এটা আমি টালি বি কলু যে তার সব সিগনেচার page 28, the check under dispute. 8 lakhs. Neither the interim compensation is being paid, nor
now what do you want?
My lord, I pray because it is his original signature. So the it is not to be required to the handwriting expert.
Has the court allowed?
My lord?
Has the court allowed to send it to
Yes, my
handwriting?
lord. Court is allowed. Impugn.
Where is that? That is the order you are impugning.
My lord.
19/11/2024.
24.
Yes.
ছবারে by 30th June তাকে কিন্তু 11 new plea it is not my signature.
I'll issue notice.
My lord.
Issue notice. Yes.
I pray যে সে দেই দিও ডিসপোজ এইটি হেই যাও কারণ সে আউ
Let him come. I can't help it. Let him come.
few days he
Let him come.
yes sorry করি তার
What is the check amount?
8
lakhs.
8 lakh.
You have moved application under 143 capital A.
হ্যাঁ
Have you moved?
I have moved.
What is the order?
এটা
there?
ডিসপোজ অফ করলেন তাহলে নাই you will face the trial and after conclusion
Has he not passed any order?
the trial court has not passed any order.
Okay.
Obliged.
18.
My please, Lordship. The petitioner is doing the event management and
Yes.
he is also proprietor of the Daksha Communications. And the informant is my lord, defeated MLA. That during election, it is alleged, not here. ये तो कोई तो पुटी तो अंदर मतलब 20 lakhs का defeated MLA candidate was alleged that this has promised to pay 1 crore cash. And in lieu of you have to pay the 20 lakhs. Informant will pay 20 lakhs. Accordingly, he has paid 20 lakhs.
I didn't follow you. What
Your lordship,
exactly
what happened? Here is the informant is the repeated ML.
Huh?
Informant is the repeated MLA, your lordship, contesting the election process. Mane allege that lodge affair before the police that the present petitioner, by giving in rupees of 1 crore, has taken a rupees 20 lakhs from him. That is the allegation.
What he is
For the election process,
Yes, 2%.
and
10 lakhs, 10 lakhs.
asked you to give 1 crore.
10
By
lakhs.
giving assurance of 1 crore to give 1 crore, has taken 20 lakhs from him.
That is
That is the allegation.
How the proposed 20 is, kindly say Annexure 5. I have received 10 lakhs. Annexure 5 will also see. Page 23. ମୁଁ ନେଇଛି ଇଭେଣ୍ଟ ମ୍ୟାନେଜମେଣ୍ଟ କରି ଯାହା ଇଲେକ୍ସନ ଲାଗିଥିଲା I have taken. Accordingly, I have paid the tax. What offense I have committed, my lord? Event ମୁଁ ଗୋଟେ ଜେଲ
how much cash?
କିଛି ନାହିଁ no cash.
It's all because of the cash fraud.
No କିଛି ନାହିଁ cash
For 10 lakhs, it's all right.
yes.
Show me the allegation.
Page 18 ରେ ସେ ତାଙ୍କ informant and driver account ରୁ first 10 lakhs ପଠେଇଛନ୍ତି ଆଉ ଗୋଟେ ତାଙ୍କର ପୁତୁରା ହିସାବ ହେବେ ତାଙ୍କ account ରୁ ଆଉ ଗୋଟେ 10 lakhs ତା ପିଟିସନ account କୁ ପଠେଇଛନ୍ତି 20 lakhs ପଠେଇଛନ୍ତି
ମୋ account କେବଳ ଆସିଛି 10 lakhs lordship kindly page 24 ଦକ୍ଷା communication page 24
ରବୀନ୍ଦ୍ର କୁମାର ସେଠୀ ତାଙ୍କ driver account number so and so
Investigation is going on.
yes ସେମାନେ ସିଜ୍ କରିଛନ୍ତି ଏଇଟା ଡକୁମେଣ୍ଟ ଚାର୍ଜ ସିଟ୍ ଆପଣ 7 ମାସ ହେଇଗଲା ଦେଇନା
Okay, issue notice. Yes,
what
let us see. If you have paid, taken money, you pay. He is a politician, you have to pay. He knows how to get it. That event management is all right. The other cash you have taken, you have to pay.
ମୁଁ ଦବାର ଥିଲା କ୍ୟାଶ ସି ଆଲିଗେସନ କରୁଛି
ଇଲେକ୍ସନ ପ୍ରୋସେସରେ ଗୋଟେ ପିଟିସନ ଦେଇଥାନ୍ତେ କହିକି 20 ଲକ୍ଷ ଆଗେ ଦେ ବୋଲି ନେଇ ଗଲେ ଆଉ ଗୋଟେ 80 ଲକ୍ଷ ଦେ ଆଉ ଗୋଟେ ଦେଲେନି
ଆଲିଗେସନ କରି ହାରିଗଲା ପରେ
ଜିତିଥିଲେ ମିଶିକିରି କମେଇଥାନ୍ତେ.
କ୍ୟାଶ ଟ୍ରାଞ୍ଜାକ୍ସନ ये मुद्दे
I know you promised and you wanted to use him after.
but it is allegation not
Yes.
May please lordship. Annexure 6 is order dated 6/8/2024 passed by the sub-regional magistrate in a proceeding under section 152 of the BNSS, wherein the order has been passed directing me to remove the obstruction which amounts to final order, my lord, or restraining me. Lordship, the fact remains the ROR stands in the name of my predecessors, but when during settlement operation they did not appear,
Yes.
so land recorded in the government challenging that I prefer revision before the settlement commissioner, which is pending. Now in the during pendency of that revision under section 15B of service settlement, some persons complained before the SDM that I have encroached the government land and proceeding has been initiated. Lordship, here the order has been passed without going into the field repair report.
No, it's at the top, it just see, peruse the report submitted by the Tehsildar.
My lord, the field report, my lord, that is lordship, page 44. It was dated 23/9/2024. Detailed field report, my lord.
Yes. What do you want now?
My lord, the second condition, my lord, the opposite parties had removed the obstruction by 31st August 2024 and notice has been issued prior to issuance of
Where is that condition?
Page 49.
49, yes. Opposite party shall remove.
Shall injunct from making any changes. That is not prejudice. The second, the opposite party shall remove the obstruction by 23rd day of August 2024.
Yeah, that is government land, you have to remove the obstruction.
My lord, I have not been noticed. When the
Forget about notice. Now you are here.
My lord,
It is a government land, you have created
my lord,
obstruction.
it is government land because originally land belongs to me. When I did not appear before the settlement authority, land was recorded in the government.
Show me your title.
My lord, I have prepared the revision application. I have annexed, my lord.
Show me your title.
My lord,
Don't show ROR.
yes, my lord.
No, don't show ROR. Show me the title.
Title because because previous order I have annexed, my lord.
Yes.
Yadav report I have annexed, my lord. The wrong recording of the government kata, I prepared SRP. SRP is pending before the authority for adjudication.
Oh, the 15B application under Service Settlement Act is pending before the.
And now,
and what is the obstruction, by the way? Let us see. What is the obstruction? What is the obstruction you have created?
Obstruction, my lord, the allegation, my lord, that Nivedana Iki ji Ambe Mane, obstruction, my lord, that page 44, written report.
Yes.
Shatrughan Thakur has encroached the land by Khata number such and such, Isam Rasta, area acre such and such constructed house. Kartik Thakur, Mukund Thakur has encroached the land by Khata number such and such, Isam Rasta area, constructed latrine, and Sudhanshu Naik, Kishore Chandra Naik, son of Krishna Mohan Naik, of village Kasibahal have encroached the land by such and such number, constructed compound wall. It is my land, my lord.
Compound.
It is my land, my lord.
Your land or not, that will be decided in the other proceeding.
Because even
unless that is decided, I can't give a declaration.
If I have given an opportunity before passing the removal order, I have no objection. Because my lord,
I can't give a declaration. You have to,
because my lord,
that proceeding will decide.
My lord, on the basis of the wrong recording, entire order has been passed because that amounts to final order.
That you correct it. Unless it is corrected, it has to be taken that.
No, it is pending, my lord. It is pending, my lord.
So then, unless it is that is decided, I can't give. That will prejudice that proceeding.
Lordship,
I'll just issue notice. You will see.
Lordship, they will demolish my.
Let it be. I can't because unless you show me.
Because what the other report I have announced, my lord, not final order.
Then I'm going to prejudice that proceeding. If I'll say anything, the proceeding which is pending will be prejudiced.
Because my lord, the removal of
Whatever, I'll issue notice. Let's see.
Lordship,
Nothing.
they will
Yes.
remove my lord.
Next.
Lordship, only
Not
status
great,
quo, my lord.
nothing great.
Status quo, my lord.
Therefore, I wanted to see what are the construction.
Construction, my lord, that is.
Toilet and compound wall.
My lord.
Nothing great is going to happen. Yes.
Lordship,
Next
Lordship,
20.
They will demolish my lord.
Let
Status quo
it-
today, my lord.
Let it be demoted. But yeah, I
Status
don't-
quo today, my lord.
You move on. How can I
Because removal,
prejudice? How can I pass an order if the proceeding is pending somewhere else?
my lord, my humble submission is that I'm not agreed with the first order, that restraining order, because the order of removal that if the order of removal could have been
But
passed.
restraining order is neither here nor there unless the you remove the obstruction.
Because my lord, removal order is amounting to final order.
Short date I'm giving. We'll see what the other side ex parte order. How can I pass like this? Yes. Short order. Short. दे दियो तमें. नहीं. Give it on 17. 17. Yes. File the process.
My lord.
Immediately today.
My lord.
Yes.
20 minutes, I have to pray for an adjournment.
On request adjourn. Yes.
20 and 21, my lord, case and counter case, my lord.
20 and 21. 21 will also go like that. Yes. The request of the parties. Okay. 20, 21. Yes.
22.
Okay.
Yes, sir.
But my simple prayer is that this present petitioner be convicted under the N Act 138 preferred appeal, and here on the amount of fine, the 20% amount was direct to be deposited. Only simple prayer that is a retired person, and on merit there is a case because this check was not belong to this present petitioner. Somebody has given.
But now you are convicted.
Only a limited prayer, my lord. So far, a fine amount is concerned. That is more than 26 lakhs was the check amount. But including the check amount, it was imposed fine 46,000. So simple prayer is that if this amount of fine will not be taken as so only
Next,
that check amount.
Show me the
That I challenge that order. That is
page 33. The final order.
37, my lord. 37.
30. 2 years sentence to pay 46 lakhs.
46 lakh.
26 होची चेक अमाउंट तारे पर 20% बरं कहले से देई परिबो तापर मेरिट रे जाहबो बहुत
The appellate court has suspended the order passed by the.
It's 46 lakhs. What he says
Thereafter
is
directed
20% of check
deposit.
amount is ready to pay. But insofar as the 20% of the
fine amount,
46.
Total fine amount. That is
what he says. Right on. The petitioner is convicted by the court of JMFC, Jagat Singhpur, for an offence under section 138 NI Act, and was sentenced to undergo SI for a period of 2 years and to pay fine of rupees 46 lakhs, and in default to undergo further period of SI for 6 months. He preferred an appeal before the appellate court by filing criminal appeal number 49 of 2024. The appellate court has directed the deposit 20% of the fine in accordance with the section 140 capital. Then the petitioner submits that owing to his financial health, he could arrange to deposit 20% of the check amount. That is
26.
20% of the check amount. Issue notice to opposite party.
Yes. Obliged.
May I please, your lordship?
I make a prayer, my lord, for quashing of the GR case, my lord. On the ground that the informant or other witness, despite issuance of a summons to them, they are not appearing for, not cooperating for conclusion of the
You
trial.
will be acquitted then.
The case is pending. No order is being passed since 2020. They are not a cooperating.
Show me that they are not appearing. Order sheet.
Yeah, order.
13/8/18. Your lordship have a glance at page number 30.
Yes.
13/8/18 order ta. PW1, PW is examined the cross discharge. No other PW
But you now come to first of all the proceeding sheet which you have enclosed.
My lord.
Just see, come to page first 27. 21/7/2017. Accused absent.
21/7/17 again.
And now come to page 29. 23/10/2017 accused absent. 14/11/2017 accused absent.
I made a
12/4/2018 accused absent.
Page 35.
Again you come there 13/8/2018 accused absent. 2018 accused absent. You don't go to the court. Now you have all problems.
My respectful submission, my lord.
Delay is attributable to you because you are not appearing.
I made an application under section 317 CRPC.
No. You are not appearing. You are not.
25/11/2022 page 35.
Right on. A petitioner is seeking a direction for early disposal of the trial pending before the court of James Rajgangpur. He submits. And Rajgangpur in GR case number 272 of 2015. Relying upon the proceeding of the court below, he submits that despite repeated notice to the informant public complaint, the complaint is not cooperating with the trial, as a result of which the trial is procrastinated. I have perused the proceeding, please, before the proceeding annexed with the petition as annexure 2. The proceeding reveals that in many occasions, petitioner being accused himself has not appeared before the court, which led to the prolongation of the trial. Therefore, the petition doesn't deserve merit. However, needless to say that since the petitioner has constitutional and statutory right of free trial, the trial court shall do well to that the trial is concluded as expeditiously possible. Yes. With this observation, petition disposal. Next.
24. Please, my lord. My lord, here, my lord, the petitioner is the complainant and making a complaint against her own father, because out of compulsion from the husband, there is a very developed idea by filing the complaint to grab the property of the in-laws, father-in-law. So now, the present petitioner wants to withdraw that petition. Only issue that the complainant does not want to pursue the petition. She wants to withdraw the complaint petition. Only that direction.
Complaint where you have filed?
That is before Bhubaneswar. Annexure 1, sir.
You go and move application.
That observation can be disposed of. My lord also observe that. He can also pass the order. Because that is the domain of the complainant. If she does not want to proceed with the complaint.
Why have you come here?
Because only sort of a direction, sir. Sought for a direction directing the opposite parties that I don't want to pursue my complaint petition. Because this arises out of a complaint case. Because complaint petition has been drafted by the advocate, not by the.
But what you are asking, just prayer, just see.
Sir.
Number 2 and 3.
2 and 3 is the police. Sir,
So
oh,
SP
number
and IS.
Direct the opposite party, especially opposite party number 2 and
2 and 3 to drop the proceeding
How
GR
can
case.
how can I direct them to drop the proceeding?
Only with that observation to drop the proceeding. I cannot make the magistrate as a party here. So I cannot, can I make a magistrate as a party here?
So then see, I try to appreciate. You are seeking that there should be a to opposite party number.
2 and 3 only, because 2 and 3
The police and
yes, the
PIC and
Sir, complaint petition also filed before the London magistrate. London magistrate directed for the inquiry of that complaint petition.
156.3.
Yes.
Now you don't want to proceed.
Yes, yes.
You write a letter to the
that observation can be disposed of. I am the complainant.
petitioner.
Yes.
Appears to have filed a complaint under section 150. So cause this thing 156.3 complaint under section 156.3 CRP. Leonard, where is that order? 156.3 order.
No, sir, basing on that complaint, GR case has been there, is there.
Show me, where is that order?
Okay. Order is not there, but proceeding is
I
there.
need to know whether the order is there or not. I'll dictate it. Subsequently, it is found that there is no order.
Sir, GR case number 4.
No, you give me the order. No orders can be passed like this. I need to know what is the order. Otherwise, this prayer can't be allowed.
Sir, complaint case, any complaint case, once the inquiry is to be done, then there will be a GR case. The GR case is there.
I need to know the order dated. Which order? You just tell me the order dated.
Which order?
Which order by which
the case was
the magistrate had passed the
Say order to can
directing the IIC to register the FIR and proceed.
It is there. Out of that, the complaint case, the GR case has been there.
Pass over. Get that order. Yes, next.
The order is there.
I have to
That
I need to understand this thing.
That order is passed in the civil court.
Or civil court.
Nothing is written here.
Civil court order.
So everything is completely innocuous. You can't correlate anything in this petition. Yes, pass it over. I am just come with right information.
Here, my lord, it is a Belgian matter. My lord.
Yes.
The petitioner, my lord, jumped the bail, my lord.
23/10/2019.
23/10/19.
Yes.
Bail was granted 12/5/2011.
Okay. 5.
26. Next also same, my lord. Belgium matter.
Yes.
Bail jumped on.
Yes.
25/9/2018, my lord, the order, NBW issue. He was released on bail 7/5/14.
5. Yes.
27.
27 is matter. Belgium.
21/5/2015 bail. 15/7/2016.
16.
15/7/2016.
1,000.
Ready.
1,000. Yes.
28.
Item 28 and 30, the parties are same and it's a compromised matter. Already the matter has been settled between the parties. Both the parties have come today. What I humbly pray, let the matter be taken up at 12 p.m.
12.
Well,
20, 20, 20.
28 and 30.
28 and 30.
Well,
29.
29.
29, Lord, I am speaking Quashing of the affair, which is at page 30 of my brief, my Lord.
30.
And accepted. And
Yeah.
I am relying on the 7th round of the judgment of Vigilance. The entire prosecution is manifestly attended and lost beyond my list, my Lord. What has happened? My house was taken on
Investigation is complete.
No, FIR instituted. Your Lordship, may kindly bear with me for a moment.
Yes.
What has happened, Lord?
Yes.
My house was taken. Rent, my Lord. Rent was not given. I was given a check which bounced. I filed a complaint case. Notice was issued. Cognizance was taken.
You are the landlord.
I am the landlord. And after, my Lord, receiving the notice in, my Lord, complaint case, to create a probable defense story, a complaint case was filed, alleging an incident which is 1 year prior to the lodgement of the FIR. Your Lordship, and thereafter, my Lord, after lodging the FIR, A video was made viral through, my lord, YouTube, leveling allegations against me, naming my father, who is a reputed person, my lord. Your lordship may kindly come to paragraph 22, my lord, page 19. I did not read it. I will request your lordship to kindly go through that paragraph.
Which one, 20?
22, my lord. Page 19.
19. So 19 you are.
My lord, page 19, paragraph 22. I'm sorry.
19 you are talking about.
Page 19.
That is your petition, it seems.
My lord.
Okay. Yes. Yes.
Lordship got it?
Yes, I got it. Yes.
For some reasons I will not read it. And deliberately this was done.
What is this going on? You have to instruct your what is this going on? And she is the father is a very reputed honorable judge of this court. What is this? Issue notice and I am putting it 17th. It come and tell.
Yes.
17.
My lord, shall I take notice through special messenger?
No, he. Oh, okay. The private party.
My lord.
Yes. Private party is notice. Now let the IAC, sir. Let through IAC, yeah? Sir, through IAC. Vacated the premises or not?
No.
Not
In spite
vacated.
of several requests, she allowed his belongings to remain there. And my lord, making these kind of imputations made by.
What are the belongings? Any inventory is made?
My lord, he is saying that I had installed a software which amounts to 75 lakhs. All these kinds of allegations.
But he doesn't have money to pay rent.
No, he doesn't have.
Have you prepared any inventory to that effect?
No. Police dakile to gale ni se au. On his.
You just ask whether inventory is prepared or not. It's very easy to make allegation. She is a practicing lawyer of this court. You can't do that.
Yes.
Yes.
Obliged.
18th, let it be on 18th. Huh?
18th.
18th of okay, 18th.
The Lord
At least
issue notice through
issue
IAC.
notice to Mr. Vishwal accept notice, and the opposite party number 2 be served through the IAC. Which police station is this?
Noyapally.
Napoli.
Again.
Napoli. Okay. Yes.
Grateful.
Settle the dispute is better. That's it.
We have tried, my lord. Before coming to your lordship, my lord, we have tried.
What is the rent due now?
It is approximately 1,30,000. If I am.
You forget of that rent, let him vacate the house. Simple. He doesn't want to pay the rent. Let him come. Mentally you ready that you just forget about the rent.
I got it.
Areas of rent and all. You forget.
I got it.
And he will vacate. I'll record his, I'll ask him that he should vacate the, and let us prepare an inventory. Whatever things are lying, you give him.
As your intention is different, your lordship can gather from this.
Yes, sir. I've seen it. I've seen it. Yes.
Grateful.
31.
Belgium matter, my lord. The petition is released on 17/7/2018, my lord, released on bail, and the NBW issued on 1st October 2024.
24.
My lord.
Okay. 500. Yes.
32.
32 bail on 15/5/2023 and NBW issued on 6/5/2024.
500.
33.
Benjamin lordship. NBW issued on 26 lordship. Accused persons in this case, they are religion bail in different directions. Lordship. I have already mentioned in my para.
How many of you are there?
Lordship.
5. Which para you have said?
Para 3 I mentioned.
Para 3, yeah?
I mentioned
Para
the
3. Okay.
date of bail.
And NBW?
NBW lordship, 24,
500 each. 500 each. Yes.
34.
NBW issued by the learned my lord, under page 22, my lord.
Yes. Tell me the dates. I don't need anything.
My lord. So
Tell me the dates when you got the bail.
9/12/22.
9?
9/12. No, this is 22.
22, okay. 1000. Yes.
35.
Petitioner was released on bail on 29/10/2024 and NBW was issued on 7/11/2024.
500. Yes.
36.
36 my lord, bail on 24/5/2023 and NBW 7/1/2025, just previous month.
Okay, 500.
7.
Mother, hearing the case, petitioner was convicted under 133 by the learned JMHC for 2 years and final amount of 45,000.
Yes.
It has been reduced by the learned session judge 2 months and final amount as well. I could not appeal in time before this division before this honorable court. In the meanwhile, I was sent to the executive board, CGI. He has issued the NBW against on 2 at 24 and page 28.
20?
Page 28.
You have been, your appeal is also dismissed.
Madam?
Appeal is also dismissed.
Appeal is modified.
Modified.
That sentencing from 2 years to 2 months. And fine amount as it was.
Are you filing revision? Have you filed?
Revision are filed in the court, but it is in diary stage because limitation is the.
Filed before this court.
Yes.
Madam,
But
petition.
not in appropriate time, I could not file.
Petitioner,
Therefore.
petitioner, one minute. Petitioner was convicted. Petitioner has been convicted for offense on section 138 NIA. By which court? By
the first
by the court of Jagatsinghpur. By its judgment dated 30/8/2016. Against the said judgment of conviction and order of sentence, an appeal has been preferred.
Appeal of 23 or 22.
Appeal has been preferred, being criminal appeal number
23 of 22. It is mentioned
23 of 2020. The appellate court has modified the sentence. Modification. Before the petitioner could file the revision against the said judgment of the appellate court, the trial court on the execution proceeding has issued NBW.
Yes.
Why the order dated?
Order 2 years 24.
2 years after 24.
Passing NB Molu.
Yes.
And fixing 2/9/24 for appearance.
Okay.
And so I may be relieved so that passing and you'll see pass.
Yes, I passed.
But that was nice.
Was subject to you appearing, yeah?
Yes.
You appear.
That my very much of observation.
38, huh?
46.
46,000 rupees. Why don't you pay? You are spending so much of money coming to the High Court, this, that.
With the great respect, complaint is not mentioned. Once a check.
Forget about everything. You filed, you defended the complaint. You filed an appeal. Now you are coming to High Court in revision. And this proceeding, how much you have spent for this? Ego.
Your lordship's consent is very good, but it is not maintenance. Check once presented.
May not be maintainable, but sometimes to buy peace, you have to.
Maintainable.
And you keep on fighting for this.
Let me take my chance and oblige you, lordship.
Yes.
On behalf of Tarapasan Mahapatra Miller. My lord, petitioners were on bail Miller. But NBW was issued on.
Do you have the date?
My lord.
Date of when you got bail? Do you have?
Yes, Miller. On bail Miller.
You tell me the dates.
Date. Bail ଅଛନ୍ତି.
All of them are bail.
ଆଜ୍ଞା ସମସ୍ତେ bail ଅଛନ୍ତି.
NBW?
NBW dated 7/8/24 Miller.
24, 500 each.
9.
My deported in the Puri bar Miller.
Puri?
Puri bar.
Puri. Okay.
Let's back on 39, date of bail 2/9/2000. I NBW issued on 18/11/2020.
2020?
2024.
24, okay, 500.
40.
Alleged offense 138 of NI Act, my lord. NBW issued 15/12/2023. Till that notice has not been served on me.
Okay. Petitioner is in ICC case number 1 of
2019
under section 138 NI. He's the counsel for the petition submit that he had not received the notice from the court. Therefore, he couldn't appear before the court. It's late to the principal. Dated 15/12/2023. Okay.
Belgium matter, my lord. NBW issued on 18/4/24 and he was released on bail on 29/5/20.
42.
Hmm?
4, 5 submission. 1, 2, 3. And they still left without instruction.
Notice on opposite party number 4 and 5. However, notice on 1, 2, and 3 is not sufficient. And the postal this thing is returned with what are the observations?
And they still left without instruction.
And the still left without instruction. Express steps for serving unserved respondent. Yes.
43.
My lord, after launch.
Pass out.
44.
Appearance and fine, RSS 67 of years bail. Because that I have on court directed filed the debt charge. So I have filed the debt charge. I have given the debt charge.
What are you seeking, sir? Here?
My lord, restoration. My case is restoration.
Huh?
My case is restoration for sample 114 of year 24.
No, what are you seeking here?
My seeking is notice to opposite party. 235. Earlier to 231 of year 16 already notice to the opposite party. In the meantime, I have not given the postal requisites. So case is dismissal default. After that, I want to I'm ready to file the requisites 235.
Nice. Yeah. Delay.
Delay, my lord. The restoration one
431 days delay.
My lord.
Therefore, you have to explain. The explanation is not sufficient. Therefore,
My lord, this is restoration.
But next item in my case.
oh,
234.
which one?
235 notice complaint.
44. Okay, okay. Okay.
44.
44. Okay. In this case also, there is any delay? Is there any?
During test of admission, case is dismissed or deferred. After that, I have got the consent from the Subudhi advocate. Then I have filed the bill advocate of test.
What is it?
It is a restoration case.
What are you showing?
My assumption that the restoration order and the restoration may be taken good and regular man, sound and regular man. This is a Supreme decision.
RSA.
Madam.
RSA. Chalo, notice was issued already?
I don't notice opposite party was alone represented the opposite party. 1 and 4. Notice substance. 235 not notice substance.
What happened, your lordship, but as per the date set, what happened, second application filed, that was dismissed. Again, CMP was filed. In that case, notice was issued to the private respondent, but inadvertently, by non friend is not filed the requisite for issuance of notice to the CMAPL application. That was also dismissed.
Second time I have not filed. Second time. First time I have filed. Second time I have not filed.
That I know.
I not filed.
Again,
Because they are living outside Bangalore. Now they come. They do Corona. They are living outside. Opposite party restaurant. Come to the village now. Still going on. Two applications are pending.
1 minute,
Two applications are pending.
I am thoroughly confused the way you.
Two applications are pending.
Let me
Counsel.
let me read it and understand. I'll do it. Yes.
My lord.
Your second appeal is dismissed.
My lord, second dismissed.
Thereafter, you move an application for restoration of that.
My lord.
That restoration application is also dismissed.
My lord.
Consistent. And now you move an application for restoration of that CMP.
My lord. My lord.
And there is a very detailed order by Justice Das.
My lord, first very.
How will you get over this order?
My lord, second appeal is dismissed for default of duty in the point of admission.
No, first of all, you tell me why.
First date, my lord, opposite party advocate is present. Then that second appeal.
Why the CMP application is dismissed?
My lord,
there is a very detailed order.
My lord, due to other court, I with the other court.
I just issue notice.
My lord.
Issue notice. Issue notice. Let them come. And you don't file requisites also.
My lord, 2, 3, 5 for the second cancel.
Very casually you have done.
बाहर उतरे माइलर से opposite party बाहर उतरे तीन जन आपको गुपी advocate आसुना है कोर्ट में.
It's very difficult to restore, but just.
advocate दिन आसले कोर्ट काम किया था.
Okay. Yes.
हाँ. तब सीधे तो वही जांच की.
At least file the requisite. I have issued notice.
Like 431 days delay, my lord, for restoration.
Yes. How will you explain it?
Explain, my lord. Actually, my lord, I had missed the list.
I'll issue notice. I'll issue notice.
My lord, state is the party, my lord.
State, yes, madam.
So you lordship, my lord, impose some cost, my lord.
No, what are the reasons?
The reason, my lord, lordship, my lord, I have given the reason on that particular day, my lord, when the matter was listed before the court, my lord, I missed the list.
No, that's right. You missed 1 year.
Yes, my lord. After that, when I filed my lord, I wanted to file the memo for listing, my lord. I came to know about that, my lord, that was dismissed since long, my lord.
And this is the solitary explanation you have given.
My lord, that is the fault of mine, my lord. I have all the.
Can you file an affidavit?
My lord, I have filed the affidavit, my lord, and taking the blame to me, my lord. I have missed the list, and it is my fault, my lord. Due to my fault, my lord, my client will suffer.
What is the matter, by the way?
Matter here, my lord, I am.
Do you have any merit on?
Yes, my lord, I have. That is why your lordship was pleased to, my lord, grant interim stay, my lord, in this case, my lord. Here, my lord, I have the FIR, my lord.
You are really interested in that stay only, or?
No, my lord, I want to, my lord, dispose of the matter, my lord. After restoration, any day, my lord, your lordship will put, my lord, I will argue the matter at length.
I'll restore without the stay then?
No, my lord, I don't need to stay now, my lord. I want that your lordship will file.
What is the matter? Let us see. Main matter.
Matter, my lord.
There is something on merit, then.
Yes, my lord, I am submitting, my lord.
Yes.
3 FIR have been filed, my lord.
Yes.
It is both, all the 3 FIRs, my lord, unknown FIRs, my lord. It is under section 436 and other allied offences, my lord. In the first FIR, my lord, the charge sheet was against me and order taking cognizance was taken, my lord. In the second, third FIR, my lord, final form have been filed by the investigating officer, my lord. And in the 3 FIRs, my lord, the statement of the accused person are same, my lord. One Thamba,
and my lord, if your lordship will see, my lord, the two persons were examined, my lord. On the basis of the statement, my lord, two cases were my lord, finally, my lord, final form was filed, and in one case, my lord, the charge sheet was filed. It is political rivalry, my lords. That
Who are you? Who are you?
I am an outsider, my lord. I am no way connected, my lord. They have stated that in the my lord, statement before the police, my lord. They have stated that being instigated by my lord, they my lord, they took fire in the car Fortuner, and they also threw my lord, kerosene bomb to the window of the ex-MLA.
What do you say?
My lordship,
Can you just see on merits? What I'll do is, I'll restore it and hear on merit. Because it is a 2006 matter.
My lord.
And,
2002.
2021,
my lord.
no,
CRLMC of 2021, 2294 of 2020.
21,
Yes.
21, 21. You get ready, main matter.
Yes, ma'am.
I'll restore it and hear the main matter.
By imposing some cost to the bar.
Huh?
By imposing some cost to the bar.
Like, I'll impose the cost, and if there is something on merit insofar as the CRLMC is concerned, then the question of restoration arises.
My lord,
I'll not hear the, I will hear the main petition.
My lord, lordship, kindly give me 2 days at least for my preparation, my lord, today.
You
Because
prepare and come. I'm
My
just
lord,
not passing any order. You prepare and come insofar as criminal MC is concerned. Okay? And if you satisfy me, I'll restore it. And
my lord,
if
I'll
there is nothing on the merit,
No, my lord,
then I'll dismiss.
My lord, I will satisfy your lordship because
That's the best way of doing
my
it.
lord, what my lord, it is why my lord, I am taking the blame to myself, my lord. Earlier, your lordship my lord, had the matter at length, my lord, and called for all the records, my lord. The record was with your before your lordship, my lord.
It is there.
Yes, my lord. That is why, my lord, I am worried, my lord. I have a very good case, privacy case in the CRLMC. Not that, my lord, if your lordship will see the order, previous order of this honorable court.
Okay, then I'll restore it with cost. Huh? Right. How much cost will pay?
My lord, your
The
lordship.
bar you pay.
My lord, your lordship kindly impose.
Right down. For the इधर लिखो CRLMA लिखो the CRLMA is suffering a delay of
31 days.
31 days. To explain the delay, the petitioner in his application has implicitly stated as under para 2, 3, 2, 3, 4. 2, 3, 4. Mr. Vishwajit Naik, legal counsel for the petitioner, fairly submits that it is due to overlooking and the mistake in his office, the delay has really caused. Therefore, he submits that subject to putting him to terms, the delay may be condoned. Regarding head to the submission made by Mr. Naik, the delay of 431 days is condoned, and subject to petitioner paying. How much you will pay? 10,000 you pay to bar 10,000 rupees to the High Court Bar Association for Association. And the CRLM is allowed. The CRM, what is this? CRLMC number 2294 of 2020. One is retro to its original file, least the matter for disposal. Okay. Disposal. I'll just
this case, Mr. Das will conduct the matter. Your Lordship.
75 pages.
Senior court. May kindly fix it to Monday. Your Lordship.
No, not Monday. It will go to its usual time.
My lord, Mr. Das is busy. Your Lordship, that's it.
Maybe, but we can't adjust the list like that. Yes.
Next week, any
Yes.
date, Your Lordship? My lord, item.
Yes, item.
Pardon, Your Lordship, next week, any date?
28 and 30. 28 and 30, yeah? Yes.
My lord.
28.
The affidavit is also ready, because matrimonial dispute.
Yes.
Because of that dispute, these cases have been filed. And day before yesterday, it was compromised before this honorable court in matter. I have already paid 33 lakhs as has been decided between the parties. So
Shall I take it at 2 o'clock? 2 o'clock. 2 o'clock.
Okay.
Let it be affidavit and all. Bring
Yes,
affidavit. And
I am having the affidavit, I will file it.
yes. 64. 2 o'clock. 2 o'clock. Yes. Yes.
46. Right, item number 46, I have appeal for the.
Item 46. Next week, Your Lordship, I will pay the entire award amount. I have to deposit, pay the receipt, my lord. I'll file next week, my lord. Can be disposed of next week.
No, deposited all.
I've already deposited, but the original receipt is not with me. I have to collect it and file it. So, Your Lordship, keep it to next week.
Tuesday.
My lord.
Tuesday.
Yes.
And can it be Thursday next week, my lord? Monday is a problem.
Okay.
Next week, I report
Wednesday.
Wednesday, huh? Because my friend has already entered appearance, it can be disposed of that date.
Yes.
And next item, Lord, we have discussed.
Yes. 47. Have you changed the?
You have already paid certain amount.
Necessary changes you have done?
Certain changes, my lord. Yes.
But the total amount is 21 lakhs 31,000, that will reduce to 16 lakhs 50,000. And there are two interrelated applications, one for condonation of delay, another for deposit of the amount.
Condonation of delay allowed for the reason stated.
Delay may not be condoned and the award amount already deposited.
Amount already deposited. In that view, the application is disposed.
My lord's usual.
And main matter is also.
Usual order, my lord.
Yes.
Take my lord, kindly taken up on 19th, my lord. I will discuss, I have already discussed with Mr. Tripathi. I will dispose away.
19th, huh?
19th, my lord.
19th.
49, my lord, there is a board of payment, my lord. Mode of railway appeal, my lord. Mode of payment. That is only 10% has been released in favor of the claimants, my lord. As per your lordship, it is 50% to be.
Delay is there, my lord. Delay is there.
60 days. Your lordship passed this order in last occasion.
Mode of payment, huh?
Yes, my lord. Mode of, that is mode of payment. 50% to be released in favor of the appellants, my lord. Parents are the appellant in this.
And allow it.
He is in
Change it and give.
Yes, he is.
This is item 49. Huh?
My appearance, my lord, I given the.
Change the.
Okay.
This. Yes. Whatever necessary change. Pension to the. Yes. Yes.
May I please? I am from Pittsburgh.
Yes, madam.
One week requisites some place.
Sorry? Taking adjournment?
In the after item 50 was mentioned that he is appearing today and the requisite not filed for issuance of notice. The lord has said that cost is to impose.
But the requisite is not filed, huh?
Item
Who is
50.
appearing for petitioner? You are appearing for whom, madam?
Ramesh Chandra Das.
Sorry?
Ramesh Chandra Das, petitioner.
Requisite is not filed. You have not filed requisites.
1 week, please.
Also said he appeared. That is Bhaklana today. The lord has said that yes, he has not filed.
Okay. Somebody was mentioning. 57. Notice was issued to the opposite
opposite parties, however, requisites are not opposite party number 2. However, requisites has not yet been filed. And then counsel for the petitioner takes 1 week time for filing the requisites. Let him do so, at least the matter. Yes.
51. May it please your lordship. My lord, this case is one of this example where there is an abuse of process of law by filing of a petition 125, in spite of the very fact that the self-same competent court has already observed that she is not entitled to any maintenance under section 9 of the HM Act, Hindu Marriage Act. The brief fact.
That is restoration.
Restoration she had filed. In the restoration, the husband had filed for restoration of conjugal rights. She had filed a counterclaim claiming maintenance therein. And in section 9, it was observed that she has deserted the husband.
So show me the observation.
Yes, my lord. Directly to the section 9 order, you will see at page 39.
39, yes.
Yes. So that is internal page 25 of the order of restitution of conjugal rights, my lord. If your lordship sees issue number 5.14 in page number 13, just 5 lines above.
Yes.
That. So the prayer made by the respondent therein means opposite party here.
So which page?
Page 39.
Running page?
Running page 5 of the order.
Running page?
Running page 39, my lord.
Okay.
Sorry.
Yes. Yes.
Here the issue number 5, it has been written for.
Yes.
Point 14. So just 6 lines above. That. Lordship gets it.
Read it.
So the prayer made by the respondent in her counterclaim is not at all acceptable, as she is not entitled to get any relief towards her monthly maintenance. Accordingly, this issue is answered negatively of the respondent wife. Before that, the voluntary decision is written, the finding is at page 37, running page.
She is not entitled to get any
maintenance and
monthly maintenance.
Yes, and there is a voluntary decision.
She filed,
thereafter, she files without disclosing this order. She has filed.
So you are seeking quashing of
yes,
the entire.
That 125.
Petitioner has filed the present petition seeking quashing of the ICC case. What is that?
This is CRP number 233 of 2022.
22 initiated by the opposite party.
Sorry for the interruption, my lord. Notices have been issued already. Now, in spite of the interim order issued by the previous bench, my lord, another execution petition has been filed and that is being proceeded with. There, I have been precluded to file the evidence in the.
So what are you seeking here?
Here for quashing of the entire proceeding, but for now it has come in orders.
So who is appearing?
Notice has been undelivered because the absentee has left without any.
What to do now?
Twice I have taken notice, requisites I have filed. Now I'll do the paper publication, but for now the main thing is the execution petition.
There is a stay already.
There is no stay on the execution petition. There was a stay on the.
Have you filed any application?
Yes, yes, my lord.
Yes, where is that?
That is IA number 123 of 2025.
Yes.
There are also annexed
notice non-APS for opposite party number 2. Mr. Rathol and counsel for the petitioner submits that you take necessary steps for substitution service. Mr. Rathol, by taking me to the findings recorded by the family judge Barampur in what is the case number?
EP number 233.
No, civil proceeding number 262 of 2018. 18.
Yes.
submits that while dealing with the application under section 9 of the Hindu Marriage Act, the court given a categorical finding that the opposite party number 2 is not entitled to any maintenance. And despite the said observation made by the courts dealing with the petition for restoration of conjugal right, the opposite party has initiated the proceeding under section 125 CRPC. The execution proceeding being
In CRP number,
being CRP number 233 of 2022 is arising out of the aforementioned proceeding initiated by the opposite party. Hence, he seeks an interim direction for staying the said proceeding. Since the opposite party has not entered appearance despite service, and there is a categorical finding recorded family judge Brahmpur that the opposite party is not entitled to maintenance. I'm inclined to pass an interim order staying the proceeding before which court? Family
Court, Berhampur.
In CRP number 233 of 2022.
In-
Till next date appearing.
My lord, CRP number 220 arising out of CRP.
233.
CRP is the main petition. Execution petition is CRP number 220 of 2024.
220 of 20.
Hmm?
49.
My lord, delay in filing the requisite matter, already filed the requisite today, my lord.
Not for the petition submitted. You filed the requisite today, and let it be accepted and
My lord, so we are voluntarily appearing, my lord, for the opposite parties. I pray for next week, my lord.
This is shown to voluntarily entered appearance and seeks time to file the response.
Continue, my lord.
Yes. Enter to continue. Yes.
Well, Lordship, item number 53, I pray for a short adjournment. Lord, I am appearing for the opposite party. My wakalatnama was filed on 12th, but it is not on record, my lord.
Lord Counsel of the petitioner seeks an adjournment on the personal ground, and opposite the Lord Counsel of the petitioner opposite party number 2 submits that though she has filed the wakalatnama, that has not come on record. Registry to verify the same.
54.
And it is a particular case where though the notice was received by the wife of the present petitioner, and to that effect, I filed a decision of the apex court. But the learned trial court observed that at the time of judgment, appellate stage, it should be considered. So only simple period that this same considered appraise. It will ignore the apex court judgment of the
So what are you seeking?
As per the mandatory provision that a notice has not been made sufficient on the accused. So the case is not at all entertainable. Say, lighted a dissent, my lord, past.
Which paragraph?
Data page last what one. Last page.
Appellant's wife. Served it.
Only simple, I do not want to waste the valuable time of this on court. My lord, kindly have a glance over the running page 16 of my petition. 16.
1 minute. What does that say?
that objection it can be disposed of. The decision relied upon by the petition is not applicable.
Where are you reading?
My lord, running page 16 of my petition,
Hmm?
the order passed in 1cc 1/1/2019.
Yes, that is legal notice you have.
Last part, my
You-
lord,
Which part you are reading?
last portion, my lord,
Last portion of what?
page 16.
Yes,
The decision, my lord, sixth line from the bottom.
that is page 15. Yes.
16. The
Yes.
order is page 15,
Yes.
but I am placing the portion of running page 16. Last
Decision relied upon by the petitioner
My lord,
is
my
not
lord.
applicable. That is page 15 only.
Since
Yes.
the same is decided on merit of the case by the appellate court, which is not the case of available in the record. How
But
this
you moved an application
My lord.
for dropping of the proceeding
Bas.
because service is not complete.
Mine.
And the court has said that
This was-
this judgment is not taken care of.
Not taken. This much my
To move a fresh application.
My lord.
Right on. The petitioner is agreed by the order. Where is that order rejecting your application? This one.
14/8/2024. Running page 16 the date of 15 RMIs.
Yes. Petitioner is agreed by the order dated 13/8/2024, whereby his application for dropping the proceeding initiated against him under section 138 NI Act has been turned down. And counsel for the petitioner submits that the admitted case by the opposite party that he has served the notice on the wife of the present petitioner, The service of notice, statutory notice under section 138 NI Act is not sufficient if it is served. If it is not served on the accused, not served on the accused, not serving the accused. The trial court has rejected the application and proceeded with the complaint. The counsel for the petitioner is relying upon the judgment of so and so. So and so. The judgment is either true. The Honorable Supreme Court has authoritatively held that the notice, statutory notice under 138 NI Act needs to be served upon the accused. Even if the notice is served to the wife of the accused, the same is not treated to be sufficient notice. No sufficient. In view of the aforementioned judgment, the counsel for the petitioner submits that he would withdraw the present petition to move a fresh application before the trial court if for dropping the proceeding initiated against him by the opposite party. If such application is moved, same shall be considered in the light of judgment of Supreme Court and so on and so forth.
Okay.
Yes.
Item 55, after the order dated 16/1/2025, the petitioner deposited rupees 1,000, my lord. Extension of time, my lord. So may I pray for extension of time without imposing further?
Extension of time?
Extension of time of surrender, my lord.
Okay, extension of time for surrender. 10th March. For the yes.
Six. May I please, your lords? In this case, my lord, present petitioner pray for the quashing of the affair, my lord. In the meantime, part charge sheet filed, my lord. Present petitioner is a student, my lord. There is no specific allegation against the present petitioner, my lord. Allegation is omnibus in nature, my lord. What happened, my lord? Out of 12 accused, 9% already released on bail, my lord. That is the political issue, my lord. Affair is, my lord. ଏଇକି ଯେ ଜଣେ କର୍ପୋରେଟର ତାଙ୍କ ଅଫିସରେ କାମ କରି ସାରିବା ବେଳେ ପୂର୍ବରୁ ପ୍ରସ୍ତୁତ ହୋଇଥିବା କୈଳାସ ସାହୁ, ଚିତ୍ତରଞ୍ଜନ, ମଦନ ସାହୁ, ନବୀନ ପୁଅ କୈଳାସ, ସନ୍ତୋଷ ସ୍ୱାଇଁ, ଅଶାନ୍ତ, ସରୋଜ ଦାସ, ଅସିତ, ଅପେରା ସନ୍ତୋଷ ନାୟକ, ରାଜୁ ସାହୁ, ସଞ୍ଜୀବ.
Yes, what happened?
My lord,
investigation is still going on.
Yes, my lord.
What happened?
Charge sheet filed, my lord.
Our charge sheet
How can I quash it?
since long, 2023.
Maybe, but.
Your Lordship, director other accused release on bail, my lord.
Then you
Your
put
Lordship,
application.
surrender.
Yes, right on. Petitioner is seeking quashing for the FIR number so. Allegedly state against how many accused?
12 accused now charge sheet. Amar charge sheet asking again. Charge sheet.
Allegedly registered against the petitioner beside the other accused persons. Mr. Das at the outset submits that he would not press this petition at this stage because the investigation is still going on and the preliminary charge sheet, only preliminary charge sheet has been filed again. He further submits that the co-accused persons have already been enlarged on bail. Therefore, he would surrender of before the court on or before 15th of March and resort to the remedy available to him under law. It is open for the petitioner to move for bail, on all the grounds, including the ground of parity. Yes.
Oblige.
Okay. On behalf of Mr. Pitambar Jana,
I'm appealing for the OP, my lord.
Is appealing.
My lord.
There is a request for adjournment. So wanted appeal for opposite party lead matter. Yes.
59.
Scope is the review is limited, my lord. Only, my lord, since there is a substantial question is not considered, review is not maintainable, my lord. I prefer tomorrow, my lord. If some more required.
Fact remains, my lord.
Tomorrow, what will be?
Review has been filed and obtained the interim protection, not complied the order of this honorable court, where the accounts has to be furnished. Harvested the entire land.
No, this is not order.
Yes, that is there. You have not appeared in the trial court as well as the.
No, trial court.
Let us see.
On the last occasion, your lordship may kindly see the order.
On what ground review is sought?
My 100 subsection 5 was not complied at the time. Substantial question was not pending.
That is appeal, not review.
Your lordship correct, but two substantial question was not that that I have mentioned that.
If section 100 is not complied, or substantial question is framed, not answered, or not framed, whatever, those things are you can raise in the appeal. Where is the question of review? Order 47.
Substantial question was framed.
One substantial question
required.
I am saying that substantial question, which only one substantial question was in favor. I saying that there must be two substantial question. I pleaded my review application.
Challenge that order.
That observation because that my substantial.
I will simply say that you are withdrawing it to resort to the remedy.
No, Millard, your lordship.
Available to you.
No, Millard, my humble, no, Millard, I am submitting
you get
that my submission
benefit and file it.
Millard, my humble submission may be recorded that since the substantial question has not been recorded, Millard, at the time of hearing, it was not framed. We have stated in page 4, Millard. So for this reason, I have the review court I have involved. That is
no, that is bad.
1 minute. For that reason,
I prefer the review, your lordship.
Review is not maintainable, sir.
Millard, if the order, Millard, at the time of 100, Millard, I only one submission, Millard, say 100 subsection 5 provides, Millard, that your lordship subject.
Okay. Yes.
That your lordship's consideration.
Yes.
Your lordship section 100, your lordship.
Yes.
The subsection 5, your lordships.
Appeal shall be heard on
the so formulated. And the respondent shall at the time of hearing appeal be allowed to argue the case does not involve the such question, my lord. My humble submission, the formulation of question was not been properly done at the time of hearing. That, my lord, my submission.
I agree with you.
That is my humble contention.
I agree with you, but that is for the appellate court to decide.
But that submission may be
review is only on the ground of apparent error on the face of record. Discovery of documents, which is
instead of withdrawal, my lord, that, my lord, my submission may be recorded because
you want that your submission to be recorded and dispose it up. I'll record the submission. Say that these are.
I just says that substantial question has.
All
been
right.
answered.
No,
Okay,
it's
right
not
up.
at the time.
Yes, proviso can
If,
see the proviso.
where is that ground you have taken in the review?
That your lordship page 4, your lordships, paragraph 4 and 5. And grounds also mention, my lord, that in the respect of the
Right.
review petition or
The present review petition is preferred against the judgment of which court? Judgment of who?
this court. Annexure
Judgment dated. Judgment dated.
judgment dated
what-
21/1/2022.
21/1/2022
Yes,
passed by
15.
this court in RSA number 184 of 2012. The ground of review precisely contended by the petitioner is as under para 4 and
5, your lordship.
para 4 and 5. Para 4 and 5. Okay. Para 4, 5 of the petition. Para 4, 5 of the petition. Then counsel for the petitioner submits that under subsection 5 of section 100, it is mandatory. It was submit that subsection 5 of section 100 mandates the court to frame at least 2 substantial questions of law.
Yes.
And delve upon those questions of law while dealing with the second level. However, in the present case, the coordinate bench of this court has not dealt with the requirement of section 5 of subsection 5 of section 100. Hence, he is seeking review of the judgment in subject. Impugn judgment. That the counsel for opposite party vehemently oppose the prayer made by the petitioner on the ground that the ground so urged by the petitioner to seek review of the judgment is not coming under the purview of order 47 CP or order 47 CP. I am completely in agreement with the submission made by the counsel for the opposite party, hence I am not inclined to entertain this petition. However, dismissal of however it is, and however we need like to say that the petitioner has right to appeal against the
that liberty.
judgment.
Unless, my lord, he has.
Section 14 benefit in any case is getting. Needless to say that the dismissal of the review petition shall not preclude the petitioner to resort to a remedy of appeal if so advised.
Obliged.
Even if I don't write, he has right. Even if I don't say that, he has a right to appeal.
He has a right to appeal, but by clicking the review right to appeal, then
no.
condone the delay.
This order is not appealable. He will challenge it. RSA order by taking benefit of section 14.
But there is case of order section 14. That is there.
Save the limitation. Yes, this was yes.
Item 60.
In first matter, that is
how many matters are there?
Here 4501 on behalf of Mr. Production Mishra, I pray for time, my lord, next week on any date because his grandmother is seriously ill, so he has gone to.
I am in sub item, my lord. I am in sub item, and on the last occasion, she was instructed to obtain instruction and by to supervise this case by the SP concerned. Then, my lord, report was received, but on the next date, that the Lord in Council appearing for the state, he has not gone through the report. For that reason,
Yes.
he asked some time to verify the report. Report is there.
Yes.
The report is that the case is lodged by the informant is false, mistake of kind of false given, but I am not the CDO. Basically, whose statement?
I'll put it.
Yes, both the matters taken from next
Simply adjourn, huh? Simply on request, simply adjourn.
Yes, sir.
There is a problem in the family.
My lord, problem is my lord.
I am appearing to the OP number to husband and wife, my lord. Wife with the informant. They are continuously coming to this honorable court.
Let them appear online. Why should they come?
My lord,
My lord, online.
Let them appear online. Why are you bringing them?
My lord.
my lord,
That this facility is there. Let them appear. Don't
both
bring
the
them.
petitioner and the informant of this case, they will appear on online.
Yes, yes.
They will not come to.
Online is as good as appearing in the court only. Yes. Yes.
61.
My lord, fix of the date.
A date will be fixed. Date fixed.
I accept 20, my lord, because I have some difficulties on 20.
Yes.
Sorry.
Yes, madam.
May I please, Your Lordship? Your Lordship, kindly see the last order, my lords. Your Lordship's order.
Yes.
Your last occasion, a report was called for from the IAC Hirakud on dated 28/11/24, on the basis of which Your Lordship had asked us to take instruction.
Yes. Have you
Well,
got
here, they have absconded, but we have already taken an anticipatory from this honorable court. And into December 2016, he has been released by the court below. I have the entire order sheet with me.
How are you saying? He has taken anticipatory bail and have you got any written instructions?
Yes,
What are you seeking in this petition?
I'm seeking the quashing of because this is a case, my lord. Agar truck driver, truck owner, it is a allegation is that a truck loaded with aluminium from Hindalco was supposed to be delivered at Calcutta. In the midway, the owner lost track of the truck and the driver, and he lodged the FIR against the driver that he has misappropriated of 18 lakhs of some odd of aluminium ingots. Then investigation charge sheet was filed in which it was 396, my lord. The driver was kidnapped and was killed. And this person, petitioners, they were liable under section 412, that is receiver of stolen property, and that too only on the implication of co-accused. On the main accused persons, Nasir Bucks and one Kesari Samantrai, they have only implicated that we have sold these aluminium ingots to these two people, but no seizure, no incriminating material against these persons except statement of
truck was found or not?
Truck was found in an abandoned condition in Calcutta, which has been given in Jima to the owner also subsequently. Thus, nothing has been seized.
Recovered from you?
No report, nothing. Nothing has been seized from this present.
So what is this stage now?
My lord, this state is still pending, my lord, and these persons have been represented on every date in the court. And this, your lordship, kindly see, only the first aspect may be clarified, my lord, that this person is already been
Then
released.
why don't you move application there in trial court?
Trial court.
I'll cause that NBW and go and appear.
Well, NBW doesn't exist anymore because they have been released on bail. So that has become infructuous. My prayer in the IA has become infructuous.
Okay.
Because subsequent to your lordship's order.
Which IA?
Well, I am praying for quashing of the proceeding only on the basis.
Let us dispose of the IA first. Which IA? So,
IA is, my lord. IA number 2118 of 2016.
yes.
We disposed.
The petitioner has already been enlarged on anticipatory bail, huh?
Yes, my lord. That is the order, my
By
lord.
this court, by the order dated 9/12/2009. It's not anticipatory, regular bail.
No, anticipatory bail, but he surrendered and he was released.
Okay, the pursuant to the order of this court, a very anticipatory bail.
Bail order is, my lord, 30/11.
The petitioner appeared before the court and thereafter he was enlarged on bail. Therefore, nothing survives in this application accordingly disposed of. leaves the matter for final disposal. Final disposal in tribunal to continue. In tribunal to continue.
We'll take a later part March there, so because and interim order to continue.
Yes.
Applies. Applies.
And compromise, my lord, but the parties could not come. Your lordship may fix it to Tuesday or Wednesday so that they will appear in person.
Wednesday. Yes. Date will be given. Let us pass over better.
24.
Kindly 2 weeks more time to be given, the lordship, for filing the order. Order only to obtain the order.
Sorry?
Your lordship, 2 week time at least may be given to file the order.
For what? What is this? Okay. You please get those orders so that at least it can be disposed of. Okay. Next week?
Next week, your lordship, 2 weeks after.
2 weeks, 1. I can dispose it up unless you give those dates. How can I write it? Okay.
28. I have already filed affidavit and recently order passed by this honorable court in Marta. Lordship, may kindly name.
Okay. 13 accused. 13 accused.
One case 13 accused. All the family members have been made party. And party itself.
How many of them are present today?
The husband both are present. The wife doesn't want to proceed with the case.
But what about the other people?
They are accused persons. As per the information given by the wife. Wife doesn't want to proceed with the case.
But they see if you go, it has to be quashed. The accused person has to be there, and unless one of the for other accused person, at least you move application explaining exemption.
He needs filing this affidavit on their behalf. That I can say.
No, whether they are alive, they are there. How do I know? You have move a small application. I'll pass the order, but move an application seeking exemption from appearance, giving right. That's what I'm saying. For personal appearance dispensation, you move an application.
Yes.
And
One in all the cases, both the cases,
yes, 30. Let us first complete this 28. Who is Anulekha?
Yes, Sonalikar. And husband is Subrat. Subrat. What is the terms of settlement? Terms of settlement?
30 lakhs have been paid to the wife.
30.
33.
No, 33. Okay. And the marriage is dissolved. Where is that? Oh, in the Mata case, huh? Right.
They have given in the joint affidavit that they have mentioned.
At the instance of opposite party number 2, FIR number from the court of against the petitioner. The allegation of the petitioner. The present matter is arising out of the matrimonial discord. The what is the stage? The charge sheet has been filed. The investigation in the present case is still going on. At this stage, the parties have entered into a settlement. The petitioner number 1 and opposite party number 2 are present in the court, being represented by the respective counsel and with them, and the file is sent to the copy of Warrant, case that is right to which are taken into court. Insofar as the petitioner number 2 to 13 are concerned, they are physically not present. However, where is the affidavit? Give me the, it hasn't come. However, the petitioner number 1 has filed an affidavit dated dated 0 on his behalf and on behalf of the other petitioners. Mrs. Sujata Jana, legal counsel for the petitioner, has also filed an application on behalf of petitioner number 2 to 13, seeking an exemption from their personal appearance before this court today, which is taken on record. You have to give it, taken on record. The joint affidavit filed by the petitioner number 1 and on behalf of him as well as the other petitioner and the opposite party number 2 enumerates the terms of settlement which reads as under. Para 2 and 3. Para 2 and 3. The parties have the reading of the content of the affidavit indicates that the parties have decided to put to rest all the dispute amongst themselves. Accordingly, they entered into a settlement. The petitioner has paid 33 lakhs in as permanent alimony to the opposite party, number 2, and the opposite party has agreed to terminate the proceeding she has initiated against the petitioners. The opposite party number 2, who is from the courts, has reiterated her state. Mr. Vishwal, also for the state submits that since the dispute is arising out of a matrimonial discord, the parties have settled that dispute and filed affidavit before this court. There is no legal impediment in the FIR regarding the head to the
Let's say I am for the opposite party number 2.
Yes, I have recorded it. Yes, 30.
Item 28 and 30.
494 is not there.
Yes.
Only husband and in-law.
Yes.
Mother-in-law and father-in-law. You also can
More.
quote because
Here also number 2 and 3 are not there.
Yes.
See 2 and 3 by exemption application like you. Petition 2 and 3 by petition number 1 and opposite party number 2 are present. Same. And affidavit. Where is that? Here. Affidavit. Same 2, 3, same paragraph.
Only one thing is 145. There is
Yes,
141. PSS. Line number 3.
145. 145 we have written in the. No, beginning 145 before.
Okay. Nelco PS case number 145 of 2016. ठीक है एक बात नहीं here also you file for 2 and 3 2 and 3 there 2 to 13 here 2 to 3
Father-in-law and mother-in-law.
that's right husband is appearing 2 and 3 is not appearing for them you move application it has to come on yes file it I have passed
Your lordship.
not keeping today only you give it file it here I have allowed it only formally you have to take it to the yes allowed both the petitions yes prepare and give it yes
43.
delay no how much delay
108 days.
108
But my lordship, here they have review or read petition. That order copy they have not annexed, my lordship.
Which
The
one?
review of the order which they are challenging here, they have not annexed,
where is
my
that
lordship.
order impugned order
Impugned order is not
against
there.
which you are seeking review where is that huh? 112/2000 that is important
The review they are seeking for. My lordship.
no you have to in the review petition you have to file the order against which
Yes,
you are filing
and the read appeal they are mentioning that they have withdrawn, my lordship. Only that much order is there. Yes, before this honorable court, but without any order, the impugned order is not
where
there.
is that order single judge order
Single bench order is not there, not annexed.
you file after 1 week yes yes
64.
My lord, husband and wife dispute. It has been already.
Immediate.
70.
Any urgent matters then I
70.
if there is very extreme urgent matter
Bail matter because
That matter legal. Both the parties have agreed to go for mediation.
then I'll send it to mediation 77
But where is Mr. Rai?
49 shots.
77 huh shall I have you spoken to him have you spoken to him has he agreed
He agreed to my instruction that both sides has agreed that
Sir.
we will go for mediation.
shall I record it and send it both
যেতে ভালো হয় না সে পুরি কম করে বাচ্চা
then I'll put it tomorrow if we can put it tomorrow if we'll have to send it to mediation I'll put it tomorrow please make sure
Take 1 minute.
but through the top of the list no, you mention it sir in the morning you mention it for the, as a first item wherever may be
my lord, item 70.
Yes, sir.
Admittedly, on 181 days, 181st day, the charge sheet has been submitted. That has been admitted by the government. They are still. The para 7 ta dekhi deenge.
167-2
167-2. That is the admitted case. This is the affidavit filed by the state.
where
Para 7.
where
Ebe jo Delhi se
in this petition
my lord. No, that is their statement. They have
no,
filed a
the
reply.
counter where have they filed the counter in this in this
That is filed by the state.
this is 1092 yes para counter para 7
Para 7. The admitted case is that on 181st day it was filed. Charge sheet was filed. Lambodar Bagh and your lordship has also given in Raman Das.
That is the statement made by the state. Para 7, that on the first day charge sheet was filed. That is at flag. That affidavit is at flag.
Nay, having admitted that one, what do they say then?
They have said on the next day they filed. On 23, it completed 180 days. 24 they filed. The order itself also, the impugned order also says that.
Yes, where is the impugned order?
Impugned order is at page 15. The magistrate records that.
Yes.
The session judge records that. Completed on 23/2/24. On the very next day, that is on 24/2/24, the charge sheet has been filed.
When have you moved the application?
Where? Here.
There, 1622.
This is order dated 26/2/24.
No, it was filed on 24th.
26/2/24 is the order.
When the charge sheet was filed?
Charge sheet was filed on 24/2/24.
24.
My lord.
And you filed the application on 26.
26.
So what will be the implication?
Implication, my lord.
Before the charge sheet is filed.
No, after charge sheet is filed only I can file that.
No. Then if before the day 180 days is over, that day application should have been there.
No, my lord, that Lambodar case.
Show me the judgment. That's the whole difficulty.
Yes, I am giving that.
We 180 day, the day 180 day over. That day you have to move an application. After the charge sheet is filed, you can't move.
No, it is the duty of the court to offer that yes, you are entitled to go on.
What will be the consequence? If the charge sheet has come on record on 24, you are filing on 26.
My lord, it is what it is the duty of the court to offer that you are likely you can go on bail. You apply for it.
But there should be an application.
The application has been made.
On 26, that time it was already there. Already charge sheet was there.
Your lordship may kindly see this judgment. Issue number 4. First, the learned.
Even to the extent that even if you file on 180th day and you have been released on bail, and if you have not filed the bail bond, by that time the charge sheet comes, then your right goes. To that extent, judgments are there.
In this case, I have given in the front page, your lordship may kindly go through. 4 issues have been framed, and for issue number 4.
Yes. Yes. Which paragraph?
Page 921 may kindly be seen. The Honorable Judge has framed 4 issues. Issue number 4 is relevant for the present purpose. And it has been answered from page 926 onwards.
But that's right. You have to have a claim for release of bail.
Yes.
If you make a claim after the charge sheet is filed, then what to do?
Only after charge sheet is filed can I make a
No. That's not the position of law. Position of law is when the date 180 day over, your claim should be there.
The basic requirement is it is for the court to offer to the petitioner that you are.
If you don't seek for bail, what to do?
No. It is his duty. It's his duty. That is what has been.
Yes, Mr. Ponda, what do you say? Do you have any judgment?
Counsel also. Then.
No, don't answer like that. See, the question is on 24th of August.
Charge sheet was filed.
24th of February 2024. 181 days. The charge sheet is filed. 1 day after the statutory period. No application was moved for extension of time, nothing. Okay. But the application for under 167(2) is filed on 26th. So therefore, whether the application is entertainable after the charge sheet is filed.
No, that is.
No, so give me the judgment. Give me the judgment because I remember a judgment where it says that the bail was granted, the 167 benefit was granted to a accused, but he could not file bail bond. By that time, the charge sheet comes, then the right goes. Here is a case 2 days after he files 167(2).
This honorable court is in the judgment that I have cited held that it is the duty of the court to offer to the petitioner to go. And that having not been
It
done.
says that it is claim.
Your lordship,
There should
your
be a
lordship has
claim.
also passed similar arrangement.
Let them get the judgment. Put it to 2 days, 3 days. Next week. Come with the judgment. Come with judgment. It is clear. There is no dispute on facts. There is no dispute on facts. You have agreed that in 181 day you have filed. The counter you have agreed. Now what will be the consequence? That's it. Yes. Shall I send it to mediation?
Some mediation said, they have mediation said. We have also no objection, assume that fix a time limit so that.
Shall I send it to mediation?
Yes.
77. जो एडजन कर देते हैं लिखो the Mr. Ashok Mahanti, senior counsel, and Mr. Mr. Mahanti, Satyavrat Mahanti for petition, and for person PK Rai along with the council party council appearing for both the parties conjointly submits that there is a scope of settlement through mediation. Hence, they request to relegate the matter to the High Court Mediation Center. High Court Mediation Center. Even the matter is referred to High Court Mediation Center. The coordinator is directed to fix a date and intimate it to the party, and for excluding the possibility of the settlement, awaiting the settlement report. Please the matter on so entry order to continue.
Item 66,
I can't tie the hands up for the mediator. Let him do. You cooperate, it will be done. Yes. Yes, I have given. Yes.
Item 66,
I that also I have written. Yes. The adjournment you just give. And the very urgent matter, short date.
Very urgent, your lordship.